Obrigado. Boa tarde. Voltamos para a nossa
Good
plenária
afternoon.
final.
We are back.
Peço para os colegas que puderem que atormentem aqueles colegas que estão lá
Ask
fora para
the
entrar.
colleagues
Rodrigo pode
to
entrar. Rony, por
please
favor, todo
rush
mundo
your
entrando.
colleagues that are still outside to come back.
Exatamente. Vou cortar o jeton de quem não estiver aqui. Pessoal, que evento extraordinário, que programa
This is an
maravilhoso.
extraordinary event.
Cadê o Felipe?
It's
e
a
Fernanda?
wonderful
Estão aqui?
program. Are
Cadê
Felipe and
Fernanda?
Fernanda here?
Fernanda tá, o Felipe não tá. Então,
Felipe,
parabéns pra
where is
Fernanda.
he? Fernanda,
Maravilhoso aqui o nosso programa,
congratulations.
Fernanda.
The program is wonderful.
Pronto. Felipe não tá, não ganhou parabéns.
Very
Os
good.
coordenadores
Felipe is not here. He
científicos,
doesn't
coordenadores científicos.
receive the congratulations.
Pessoal, quem vai amanhã à visita da Estelante, já deve ter recebido
Who is going to
instruções.
Estelante already has an email with instructions. If you
Tá?
are late, you're
Quem
not
chegar
going.
atrasado vai ficar aqui no hotel, porque
If
tem
you
hora
are late,
marcada para chegar
you'll
lá.
stay here at the
Nós
hotel because we have a strict time frame
visita, tá? Então, a
for the
tolerância de
visit.
atraso amanhã será de
So the
0
tolerance tomorrow for being
Número
late
dois,
is 0.
Festa hoje. Érica, explica a festa como é que vai ser.
The party
A festa
tonight.
vai ser em seguida daqui, encerrando a plenária. Quem pudesse
It will
encaminhar
follow
para
the
aquele mesmo vale a piscina. Só que hoje, com
the
todo
speeches
o
here,
aparato e a
the
decoração,
program here. We go by the
mais
pool.
uma vez agradecendo nossos patrocinadores
We
internacionais
thank
pela recepção
our
que a gente vai ter
international
agora.
sponsors
Lá
for
na
the
piscina,
reception that we will have by the pool,
banda,
with the
maracatu,
band,
frevo e tudo mais. E
local
outras
artists,
Malabaristas, modelos e modelas.
models, and
Que é isso aqui?
circus acts.
sobre o maior canal aberto gratuito.
Isso é. Gente, muitos de vocês não sabem ainda
A lot of you
que
don't know
está já no
still
ar há uns
that we have
2
on the air
o maior
for 2 or
canal
3
de
months
educação de
the
propriedade
biggest
intelectual do Brasil
education
no YouTube,
channel
que é o canal da
concerning
ABPI. Explica,
intellectual
Érica, o que
property,
está lá,
which is the
quantos vídeos
ABPI
e se a
channel
pessoa tem
that
que
is
ter
online right
algum tipo de
now.
inscrição para
So
assistir.
please explain if you need
Pois
any
então, não tem que
inscription
fazer inscrição
to
nenhuma,
follow or
totalmente
watch.
aberto e
No, it's
gratuito.
totally
São mais de
open and
500
free.
vídeos
It's
entre
over
webinars,
500
cursos,
videos,
todos os congressos
webinars,
da ABPI, desde a
all the
pandemia
conferences
até
of
o de
ABPI,
2022 e agora que
up to
mês vai entrar o
2022,
ano passado,
and
a gente
the next
só
month we'll
permanece
get
privado os
the
eventos
the
que foram
images from
realizados até o
last
ano
year,
atrás em respeito aos associados que pagaram para ter
and we
prioridade. Mas depois
still
desse período,
haven't launched
todo o
this for
conteúdo,
those who have already paid
webinars,
for the
cursos de
content
centros de
and
educação,
couldn't get in,
os próprios
but we will launch
congressos,
everything. The
é o maior
next
conteúdo
conferences,
possível que
it's the
qualquer
biggest
interessado em
content
propriedade intelectual
possible
pode encontrar
for anyone
gratuitamente no
who
YouTube, que não
studies or
precisa fazer
follows
nada.
intellectual property.
youtube.com.br
You don't have to do anything.
@siga ABPI. É
youtube.com.br/ABPI.
E dentre as novidades da nossa
And
administração,
among
está também a
among the
abertura
news
da
of our
revista da
institution,
ABPI.
we also have a
Pessoas
magazine of
passadas, não sei se a
ABPI.
Letícia tá aqui, nossa
I don't know if
diretora,
Letícia is here. She is our
não tá,
editor
explica o
director.
processo da ABPI.
So please explain the access.
Nós já temos o acesso aberto e já
We
foi
already have
informado
open
a
access
todas as edições
for
para
all
administração
editions,
pública,
for
do
public
INPI,
administration,
para instituições de ensino superior, todas que nos contactam,
all
a
the
gente
superior
consegue cadastrar a
institutions
extensão do
of
e-mail da
learning.
instituição de ensino e ela acessa todo o nosso
All we
acervo.
need
Assim,
is
está pronto,
the
e não é só
email, and we
edições
will
antigas, são
open access to
100%
the
das edições do
institution.
INPI
It's
para administração pública, para
100% of
autarquias,
all
para o INPI,
editions
para os
for
juízes,
any public
desembargadores.
organism,
Então, assim, é um
judges,
material
anybody.
bastante
So it's a lot
importante
of
para a
material,
comunidade
it's
propriedade
important
intelectual, para quem
material.
lida, e está todo aberto. Então, qualquer instituição de
It's all
ensino,
open.
qualquer instituição, administração pública,
Public
magistratura,
administration,
está aberto já.
it's
É só
open for
pedir,
anyone.
e a
Just
extensão
ask,
arroba, o
and
e-mail
you
da
will
instituição
have,
fica liberada para acesso. Só não tem
we will
acesso
grant
particular,
access.
mas sim para as instituições.
It's only open for institutions, though. It's over 30 years of magazines of IBPI. For it was restricted to associates, but now we have opened it up for everyone. What else? That's it. And we should remind you, in October, November, December, sometime this year, we will have a cocktail at the new location for ABPI.
Grandes pintores venezianos, sicilianos, né? Adornos de ouro, e vocês vão poder ver tudo isso.
We'll have all kinds of new content and everything for your appreciation at this new location. We don't know when the building will be done, but as soon as it is, we will receive you all for a cocktail at the end of the year. And we will contact our international partners so they can come as well. Thank you, Erica. And speaking of international members, please bring everyone in from the coffee break. Why am I worried? 2 years ago, we had our first honored member, who is Wilfredo Fernandes. And following our line of giving prestige to our members, we also would like to greet our new member in the Hall of Honor, Gonzalo.
E para fazer a saudação ao Gonzalo,
to greet Gonzalo, Wilfredo is prepared, and in 40 minutes he will talk about Gonzalo's life. Good afternoon. I'll be very brief. I don't. In 1994, Gonzalo was my friend already, and he had an intention of growing closer in Brazil in this IP sector. So he had 14 years in Brazil in our area, in our sector. So I explained what ABPI was and ASPI, which were the institutions that were linked in this area. And we didn't have internet back then, but there was a listing of offices in São Paulo, in Rio, Curitiba, Recife, Salvador, and that could help him. So over these 30 years, whatever happens, the student always becomes better than the professor. So I have a great honor and pleasure to give to Gonzalo. He has this honor, and he's 30 years experience with ABPI. So I, as the first international member in ABPI, he will be the second member international honor. So congratulations, my friend.
A ABPI, Associação Brasileira da Propriedade Intelectual, confere o título de
ABPI confers to a membership for Gonzalez for the great help in developing this institution. Good afternoon. It's a pleasure to be here, as always. As you know, Brazil is my second home, and every time I arrive, it's with great affection, and I love my Brazilian colleagues, and we are part of ABPI. I remember when I was resting on the beach, the president called me and said, Gonzalo, I was hoping to name you to the Hall of Honor of ABPI. Would you accept?
Obvio que sí.
Of course.
Para mí es un orgullo aquí estar acá.
It's with great pride that I'm here today and participating here every year, greeting all the international colleagues and bringing my observations, people from all over the continent. I remember in one of the conferences that was led by Brazilians, and we started seeing the arrival of international colleagues, and it was a national conference that was most important in Latin America, and it's always growing. I want to thank ABPI for the quality of all these conferences. Not only social quality, but the academic quality as well. Every day we learn, we receive information from ABPI, and we receive them in our offices. So I want to thank you more and more for this fortunate event with my daughter is here also, Agostina. And thank you very much. Good conference and happiness to all.
Obrigado. Isso. Muito bem. E agora,
very well. And with no delays, I invite our friend, Director of ABPI, Dr. Doclin, who will present the Patent of the Year Award in its 5th year.
Organiza e coordena esse prêmio já desde a sua criação.
Ricardo Boclin is coordinator
e é sempre momento muito especial,
of this prize, and it's also a great pleasure to be able to receive and recognize a great patent. Ricardo, you have the floor. Please explain what we'll be seeing today. Good afternoon. This is the 5th award, Patent of the Year, organized by ex-director Pimenta. It's not a question of me choosing or a committee, but we wanted to count with the Academy of ABPI, that is the judging organism. I thank Julio for the partnership, Ricardo Rodrigues, who is an organizer of this event. I want to also thank Professor Celso Lage and Patrícia Trotti, who had contact with me in the beginning of the organization, the examiners that evaluated all the cases, Rita de Cássia, Pinheiro Machado, Adelaide Maria de Souza, Elizabeth Ferreira da Silva, Celso Lage. And the prize, I would call Julio, if he could come up to give this award. And today we have an interesting situation, because we will give the prize and we will also see the product, because it's part of the circular economy, and the winners come from Rio Grande do Sul, and we know of the difficulty in logistics to be here today across the whole country, but they have come and they will receive this prize. And the winner, well, first of all, the prize would give this prize for a green patent. It had to have the certification of green patent. And it works very well. In this case, what we bring today is a patent conceded in 10 years from the request. And there was a demand. We know of green patents that are certified in 3 months, but this one has been working very well. And we wanted to give it away to a green patent. So I announced the winners. It's the co-inventors. Bela Moda and Senad of Rio Grande do Sul, and I want to call them to the stage so they can explain what it is.
Então, só minutinho, deixa eu me organizar aqui para mostrar.
Let me organize myself for a minute. I will be very brief.
Bom, primeiramente, quero saudar, então...
First of all, I would like to greet the president of ABPI, Gabriel, Ricardo, president of ABPI, Júlio. I just want to extend greetings and to talk a little bit about our patent, our history, the efforts that we've been making to put this into work in the circular economy. My name is João Carlos, representative of Bela Moda. And firstly, to contextualize the climate changes, they are a fact and something we are living through. And the perspective is that each day they will grow to the extremes of these climate events. And in Rio Grande do Sul, a few months ago, we had the flooding that were a big tragedy to our state. And we had a period of few hours, and the volume of rain that fell was the equivalent of 6 months of rain. And in these events that are extreme, 3 years ago, it was an event of a strong winter in which we lost 40% of soybean production and 20% of corn. So we know that a good part of what is going on has the hand of the man. Rio Grande do Sul consumes a lot of natural resources. So we won't go into an academic discussion of which one we want to criticize, or I don't know. But in this context, we have the textile companies that it generates a lot of riches, of jobs, and in the world, in Brazil. But at the same time that it generates riches, it is a problem in the industrial sector because it consumes a lot of natural resources in the production and it generates a lot of residue. So in this context, we started to research to decrease these impacts. And in the production of a piece, of a garment, there is a lot of waste. 30% of the garment, of the production of the garment, it becomes residue. These residues that you can see in my hand, a small piece of clothing that you cannot use to produce other pieces of clothing, of the garments. So for each kilo of garment produced, you have 30 kilos of residue. So we started to develop a technology that would be economically viable to transform this garment, these residues, into other pieces of garment.
São os resíduos têxteis sintéticos, tipo poliéster,
synthetic garments or elastano that are considered plastic, and that they can be transformed into a new piece of clothing. So we formed a partnership with the National Institute of Innovation of São Leopoldo in an innovation protocol for the development of this new technology.
We've been able to transform these residues, this waste, into pellets, small plastic grains, if you will. These are plastic waste, and they can be used for the industry of injected parties and the apparel industry. These residues, we've turned them into this actually injectable eyeglasses and structures for eyeglasses. This new filament, for example, we came up with a baby coat to show you the quality of the product that we generated. That's the circular economy. The reality of waste, which is a big problem because it takes up too much room, and many times they are discarded incorrectly in nature. As I said before, it's plastic. And when they're discarded into nature, it takes over 300 years to be decomposed. And we're actually in landfills, we're burying them, but we're just hiding the problem. Over 230 years ago, Lavoisier said in the Land of Conservation of Masses, he said that nothing gets wasted in nature, yet it gets transformed. So after a great deal of effort and time dedicated to this, we've been able to get to this technology. We filed for a patent, and we're implementing this technology at the industrial level in the city of Erechim, Rio Grande do Sul. We're taking up a pavilion made available to us by the town hall of the mayor's office of Erechim. We want to implement this problem. We're going to get the residues from the apparel industry and the automotive industry and the shoe industry and transform it into something that can be used back by the companies. It's a great challenge, as big as making innovations, and that's to implement a new idea. It's a big challenge that we're ready to face it. And this award that we're getting today, we look at it as the recognition of our efforts and our work. It shows us that we have a great deal of potential, and also we must remember the question of fast track for patents. We got it in 10 months. It was record time. We should congratulate ABPI for the speed at which the red tape was processed. It's crucial to have a quick process for inventors and companies that are investing in this new product and this new process to protect all the investments, to create this virtuous cycle of growth. A note of thanks to INPI and the Brazilian Association of Intellectual Property, ABPI. Thank you very much, and thank you for awarding us with the Patent of the Year award, and it's something to celebrate for sure, and it will help us publicize our work and also seek out investors in order to help us leverage that solution, and so we can get more investments to place on the market new solutions and innovations of the textile industry. Thank you. Good afternoon, everyone. I'll take the liberty to congratulate my partner João. Today in Brazil discards over 4 million tons of textile waste. 80 million, actually. This number goes up to 92 million around the world. In 2030, we will have 132 million tons a year of this mass, textile mass overall. 60% of them, roughly, it's made up of polymers. And the 60% polymers are responsible for 16% of all the microplastics thrown into the ocean in our food. So the patent due to which we're getting this award today describes the method to process textile waste and new pallets. And of course, this is to actually make them new textiles in the future, but also it opens avenues for new materials. Like my partner has told you, it's like hangers, automotive parts, eyeglass structures, and that shows you how to add value to residues and waste. And that's very important to show that circularity can be competitive as well. The Technology and Innovation Division of Rio Grande do Sul, SENAC, in Rio Grande do Sul has a role of developing the technologies that acts as a research and development arm of the industry, much like what we did in this. The industry is a leader. It is the industry that transforms technology into innovation, that transforms technology into invoices and job positions, while it addresses a very important environmental issue. I'd like to express on behalf of Senai Rio Grande do Sul my most profound thanks to De La Moda for this great partnership that's been long-standing, and IBPI for the acknowledgement of this award, and INPI for speeding up the red tape leading to the patent being awarded.
Então, só vamos recolher aqui para
Vamos iniciar nossa plenária
Let's
final.
start our final plenary session, thanking you for your presence, especially Appellate Judge Demophilia. If you can join us on stage, and our esteemed Vice President of ABPI, Dr. Tatiana Campillo. Let's talk about artificial intelligence and the court system. You've heard about artificial intelligence in this Congress, and that was on purpose. It wasn't incidental. Because this is the most fascinating topic, changing the world at this point. It's fascinating, and I must confess that the more I hear about it, the more doubts I have, the more questions come to mind. Something that impressed me about Dr. Alvaro's lecture in the beginning was the issue of it reminded me of the tragedy of commons. A lot of you know it's a microeconomic theory concept that says that when you have a public good, free access public good, more often than not, it's used indiscriminately up until a point at which it becomes scarce. It's a problem of externalities of corporate activities, of business activities. A clear example is air pollution. Air, after all, air is free. But as air gets polluted, it will become scarce. Good quality air will become scarce. It will turn into an economic good and will have to be sold. You may think it's ludicrous, it's absurd, but we're paying to, like water, for example, we're paying for clean drinking water. The tragedy of commons is an example, a question of farmers, ranchers that have a common grazing ground, and that's for use. And the more one rancher uses the grazing lands, it gets degraded, and everybody stands to get poorer at the end. Everyone stands to lose at the end. And so that's a tragedy of commons in microeconomic theory. As Dr. Alvaro obviously looked into this subject a lot more than I did. There is artificial intelligence vis-a-vis the use of works created by human beings. If the monetization of the original creations of human beings is put at risk, that will reduce the number of works created by humans. And we're going to have fewer works created by humans to instruct artificial intelligence, and the works created by artificial intelligence will get poorer and poorer and culturally less interesting. I'm not even talking about curious question of hallucinations of artificial intelligence. I'm talking about the problem of stimuli that we should have, economic stimuli, so that human beings will create original works that will increase our culture and our curiosity and our leisure. The use of artificial intelligence is growing, and it will continue to grow, and the legal court system as well. And that's what we're going to debate today. Before giving the floor to Dr. Tatiana for her presentation of the topic, I will very briefly read to you, very briefly, the long curriculum of Appellate Judge Demophilia. He was born in Pernambuco, Appellate Judge. In 91, he was born in Pernambuco. He joined the court system of Pernambuco as the judge of Riacho das Almas. As a judge, he acted in Cumaru, Passira, Carpina, and Caruaru. Starting in 1995, he acted in many courthouses in Recife, First Region 99. In 2002, he was auxiliary judge, assistant judge, has a master's and a PhD in law. He was promoted unanimously in 2016 after working for 24 years as a judge to the state courthouse at Pernambuco in December 13, 2016. He was solemnly invested with the role of appellate judge. He sits on the first class headquartered in Caruaru. Caruaru. Thank you so much once again to Appla Judge Demócritus for being with us today. It's an honor to have you here with us, adding value and brightness and to our closing ceremony. Tatiana, please. Can you see me? It's a pleasure to be here. Thank you so much for your introduction. Thank you, Dr. Democrito, for coming and the possibility of sharing with us some knowledge, a great deal of knowledge actually, on the subject, which is a fascinating topic. I think we're going to have two big angles on this subject, on this debate, a bit of a legislative background on how that has happened in Brazil and around the world. We're going to be listening to you, your lecture, and then at the end we'll debate and talk about its relationship to intellectual property and how the legal court system has used artificial intelligence tools. With no further ado, I'll give you the floor, sir. Good afternoon, everyone, ladies and gentlemen, here in the audience and online as well. I'd like to thank especially Gabriel, Leonardo's, and Tatiana Campillo, and Gustavo Escobar for inviting me to be here this afternoon speaking to you. When I entered the room and the antechamber, I was introduced to one of the participants of this event, and I was identified as a resident of Pernambuco because of my accent. I said, actually, because of my accent. It's easy to pick out someone from Pernambuco. But I'm not only a resident of Pernambuco. I was born and raised in a small town in Pernambuco. I come from a small town in the hinterland of Pernambuco, São José do Egito. And I'm a countryman, if you will, to a certain extent. Thanks to Gabriel for talking about my career. In a nutshell, I've been working for over 24 years and as a judge, and I rose to the state courthouse. But in addition to my main professional activity, I'm very curious about the question of the interaction between the new technologies and law. When internet, especially its graphic channel web, www, began to get popular around 1994, that's when I took a liking to these subjects, because I was able to envision new social phenomena, because that couldn't have been summed up as technical issues alone, but because of the potential of interaction and communication that those technologies led to or allowed. Automatically I identified the fact that would lead to deep-rooted transformations in society, and also innovations affect to each other and interact with our peers. From that point on, I was one of the founders of the Brazilian Institute of Law, of Informatics, of Cybernetics, of Information Technology, if you will. And that's when I began to look into these issues in earnest. Recently, I have been faced with this new phenomenon in artificial intelligence. And more recently, starting in 2021, we users had the first experience as users of what is referred to as generative artificial intelligence. ChatGPT was the first example of a model, a foundational model of an artificial intelligence system of a generative nature. We envisioned that we were all amazed and enthralled and apprehensive as well with this new reality that came up, using education on a small software package that is able to produce texts in any kind of format, literature, novels, or and it can draft, for example, lyrics to songs and answer and produce images and virtually answer any query or any question people might have. An application that practically dominated or had virtually all the knowledge, all the human knowledge in its database. With the arrival of ChatGPT, which is only one model of one company, Open Artificial Intelligence, that developed ChatGPT, but today we have many other models of chatbot, conversational chatbot, for example, the Gemini at Google, Copilot at Microsoft, Cloud by Anthropic. We have many such programs, and obviously that gave rise to issues related to regulation. Faced with this new reality, technological reality of artificial intelligence, generative AI, with a popularization and commercialization and massification of ChatGPT, in 2 months' time, it had 100 million users. With the emergence of ChatGPT and the reality of artificial intelligence, generative AI, there was greater pressure, a greater, let's say, greater demand on how to boost legislative initiatives with a view to regulating this new reality, this new technology. Because at first sight, many thought that they could, it could be like almost like an alien coming to planet Earth with a processing power of information which was inordinate, and they would soon overcome human intelligence. That's what people feared. This is artificial intelligence, machine artificial intelligence, but it can compete with human intelligence. And many people then have come up with the possibility of this kind of technology going out of control, and obviously it would run counter to the interests of mankind, people, of human beings, trample upon fundamental rights, threaten and jeopardize the security and health of people, safety and health of people. With the arrival of ChatGPT, there was a wave in the sense of trying to regulate artificial intelligence as a whole. Above all, this new kind of artificial intelligence, which is generative AI. Why do we call it generative AI? Other people call it creative or imaginative. Only with ChatGPT did we have in contact with the kind of artificial intelligence that is able to produce content. So it generates content. It generates an informational mass, if you will, hence the name generative, creative artificial intelligence. It's the kind of AI that's different from everything that we had seen before. All other applications and software packages and tools and IT systems that we all already knew. For example, we had AI and some software packages which were able to distinguish between certain images, between certain pictures, for example. But artificial intelligence, generative artificial intelligence, is a new modality. It's a new species. It's a new specimen because it produces content. ChatGPT, when we began to use it, especially in the legal system, everybody, because what's artificial intelligence, generative AI? It's that kind of artificial intelligence that is trained through huge data banks, colossal data banks, and by making use of those training data, it's able to produce generate new contents. So those are the features of generative artificial intelligence, productive information content. And ChatGPT has an additional feature. It is also a mode of what we call artificial intelligence of general proposal, artificial intelligence. What does it mean? General proposal, general purpose, better said, excuse me. All these algorithms that are being launched, that have been launched recently, in addition to producing content and information, it is also a kind of basic kit. It is a basic architecture with small changes to the program of the algorithm that can be used to undertake several tasks. That's why it's called also this kind of artificial intelligence system and single general purpose AI model. It's also called foundational models or base models. Why? Because they can be used for market reasons, commercial reasons. They may be used as also, as I said before, to undertake several tasks without developers creating a new complete software package or a totally new application. You didn't have to. They get the basic infrastructure. In the case of ChatGPT, they get the GPT architecture. They do small changes to the programming of that application, and they specialize on this foundational model, the base model, so that they'll be used in applications and more specialized applications and tasks. In your case, you work in intellectual property. For example, in the area of intellectual property, it's possible that ABPI might have already some kind of, they might have an algorithm or an artificial intelligence system that does the screening every time someone files a request for a patent. For example, they'll do comparisons and screenings with different brands. So using this new technology, the GPT technology, this base model that is offered in the market, in the consumer market by OpenAI, this base model, the GPT, can be adapted and can receive some fine-tuning in its programming so that it will then undertake a task that's more specific. Then ChatGPT and other models of algorithms similar to it have these two basic features, common features that make them different from other kinds of artificial intelligence systems that we had been used to and that we had been dealing with up until then. It's artificial intelligence that's generative, and it is artificial intelligence that it's general purpose. Generative because it generates purpose, content, and general purpose because it can be used to undertake several different tasks. With the arrival and the arrival of ChatGPT towards the end of 2020, if I'm not mistaken, the beta version was made available, and towards the end of 2020, what happened was there was already in the European Union and the European Parliament, discussions had been going on about AI, the Artificial Intelligence Act, the regulatory proposal by the European Union to regulate artificial intelligence systems. With the arrival of ChatGPT, all of the regulatory proposal that was underway had to be changed and modified. They had to include a whole chapter specifically the AI Act and the AI Act to discipline specifically these new modes of artificial intelligence, to discipline specifically these base models, these functional models with generative capacity. So there was a great deal of discussion at the European Parliament when ChatGPT came along, and its kindred systems, tools and algorithms that are similar to ChatGPT. What do we have to do? Should we treat these new models, algorithms with generative capacity as high-risk systems? I'm going to talk about high-risk systems, and I'll explain to you exactly what I mean, the logic of artificial intelligence and the Artificial Intelligence Act. These new artificial intelligence systems, should they be treated as high-risk systems, that is, systems, information systems that work through artificial intelligence and that bring forth higher risks, greater risks to health, safety, and fundamental rights, and democratic freedoms, and the democratic process, or should we then establish for them a framework, normative framework, specific, a legal framework, a legal regime that's specific to these new foundational models? That was a discussion that came up. It was undertaken inside the European Parliament as soon as ChatGPT became popular. And after these discussions came to an end, the AI Act that was still under discussion, under debate at the Parliament, was altered, and they included a whole chapter specifically geared to the regulation and discipline of what we have referred to as artificial intelligence. Of general purpose artificial intelligence. These foundational models, then, we gave them specific treatment to this kind of artificial intelligence. I would like to go back now and talk, since I touched upon this subject. We were talking about ChatGPT, but I would like to talk about the regulatory proposal by the European Union. Why is it important to talk about this normative act in Europe? Because it's the most right-ranging regulatory framework in the world. It will be applied to systems and companies providing artificial intelligence systems headquartered on the European continent, or that process data from European citizens. But today, it has become a parameter, like a lighthouse, a legislative lighthouse for all countries in the whole world, including Brazil.
In Brazil in 2023 was presented in the Senate, at least in its initial form. Then we embraced a normative text proposed by jurists to elaborate the Brazilian law. Its initial version was all inspired by the normative model of Europe. So I just want to open a parenthesis to talk about this normative AI Act of Europe. What is the conception, the normative conception of this text that seeks to regulate AI? The European legislators had several options when they started in 2017, 2018, to discuss a proposal for legislation, a text regulating AI. One of the options was in order to not stifle the growth of this new technology of AI, so that they weren't, the development wasn't stopped. There was an allegation that there was a argument that the suppliers of this type of technology would adhere to certain standards of ethical behavior, affiliating themselves to certain associations, and form new rules or norms so that they would go by. Auto-regulation. The developers of systems of AI, they would auto-regulate themselves and establish the norms, the ethical rules that would regulate the development of this new technology. The other option was to make a regulation by sector. For example, the energy sector would have a certain normative text. The agriculture sector would have their own rules to regulate the use of AI. And there was also the option of establishing a global regulation to establish norms for AI. What prevailed was this third option. And we started moving towards Gustavo, as Tatiana, Gabriel, you who know this matter, what was done with personal data protection. I know a lot of you here know that the model, the regulatory model of personal protection of data that was spread all over the world, and all over the world, countries started developing their model, was a general law of data protection. So there was a regulation in Europe of protection of data that was used as a model for the Brazilian legislation. So the solution that was found by legislators in Europe in the AI sector was similar to the experience of protecting personal data all over the world. There was a general law, a general rule of disciplining the use of AI. So that was the decision taken by the legislatures in Europe. Once that was decided to create a general law, how are we going to regulate? What are the options? We regulate everything. Should the rules have the same stiffness for small companies and big corporations? For developers in a chain, are the rules supposed to be the same? How do you do this? How do you establish a regulation for each link in a chain that uses AI? The first premise, the basic premise that inspires AI, the AI Act, is the conception of you have to have an approach related to the risks of the diversified systems of AI. This approach should be proportional between the risks that a certain system of AI offers in relation to health, safety of people, that may bring an impact, the democratic process, how it may impact people, impair government activities. So it depends on the level of risk that the system offers.
Maiores são os deveres.
And the higher the risks it may offer, higher should be also the rules and the strictness of the companies that use those systems. So, all of the regulatory conception of the AI Act in Europe is based on this premise. The larger the risk that a system offers to the fundamental rights of people and the institutions, the democratic institutions included, the higher the level of obligations that the legislation should impose on the developers. So that's the basic premise. The AI Act establishes a graduation, levels of strictness to AI systems for those systems that offer unacceptable risks to democratic values, to rights of people. Certain systems should be simply banned, outlawed. They cannot be offered in a consumer's market. So the AI Act, as is the Brazilian law, establishes a chapter that gives you those systems of artificial intelligence, allows that system to be produced, but cannot be offered in the marketplace because it offers unacceptable risk. And institutions for people and institutions of countries. So I'll give you a few examples of systems, of AI systems that are banned not only by the AI Act, but the project in Brazil, the law in Brazil. For example, have any of you heard of a system, a Chinese system of controlling society, or point systems in China? Well, in China, you have a system in which people are observed at work, at school, or public spaces. They are constantly observed, and these people will be graded through a point system because of their behavior. So you will have a social grade, and the people in the system that get a high points system, a high grade, they have privileges. And the people who don't have a good grade, they are restricted from travel or other rights. So this is a system that is used in China today. And in the European Union and other democratic countries and that are regulating this type of system is outlawed. But I could give you other systems that are being used. Here, in PL 2378, we have autonomous arms, and that is also prohibited to be used in Brazil. So when the proposal in Europe, as well as the proposal in Brazil, we have these levels of risk that AI systems may offer, prohibiting certain systems of AI that will bring risk, the unacceptable risk, to the rights of individuals. And right behind that, there's a classification that are the systems that don't offer unacceptable risks, but still they offer risks that are high, and therefore need a regulation that is more strict, and more obligations must be imposed upon these systems. And right after the systems that are banned, there is a category of the systems that are high risk. I'll give you examples. Softwares, AI products that are used in infrastructure, critical infrastructures, a system that controls a nuclear platform or that produces nuclear energy, a reactor. So this will bring risks if it has failures or it doesn't work correctly. This would fall under a high-risk system, and for the developer of the system, the controller of the system, the obligations would be very high. So the developers that establish equipment systems that are high risk, the AI Act, as well as the law project in Brazil, establish document levels and security levels and registration levels, everything to ensure that everything will work according to the plan. You have to register this system to ask for previous authorization before the authorities in that country, in Brazil or wherever it's located. And there's a third category of the systems that offer low risk for those institutions or people that develop these systems. So the obligations are also reduced, and you only have to be transparent. For example, a program that filters and separates emails. For these kinds of AI systems that offer low risk, the obligations and the legal to-dos are just as far as transparency and to say which data was used, the characteristics of that system, to inform the client or the user that is managing or using that system, so that he knows exactly what's going on so that the person can also behave adequately, and that he knows that he's not interacting with a human being, he knows he's interacting with the AI. So this is a conception of regulation, not only of the European model, but the Brazilian model as well. It is all structured with these conceptions of dividing the systems according to risk. And the European model, as well as the Brazilian model, it's been in transit since the time of 2020, when the chat GPTs came about, and AI with general proposal. In the transit of the law in Europe as well as here in Brazil, we needed to transform the legislation to include a chapter establishing a judicial regime specific to AI. And why is it so important to build norms and regulations for this category of artificial intelligence, generative intelligence, artificial intelligence? Well, first, because this type of AI generates content, so it can impact copyright. There are many cases and legal action brought against OpenAI because it was training the algorithm at ChatGPT. At least that's what it alleged, based on journalistic texts that are property of the New York Times. And there are other cases that are being brought forth against not only AI, OpenAI, but against other companies. Even Google has been brought before the courts because these systems of generative AI, they are trained, and all their learning is based on databases which englobe in their training information that are available on the internet, but they use without even referencing the authors in these intellectual articles, journalistic tests, reproduction of texts and music. So therefore, we need regulation and an individual chapter for OpenAI. And one of the basic points of the regulation in Europe is that they should respect the developers, and the developers should respect the directives of caught in Europe and in the world. At least give authorship references. Another thing, another type of risk that is considered a relevant risk for society is what Gabriel mentioned.
Eles são chatbots conversadores, pelo menos o
chatbots they want to talk a lot. They want to answer whatever it is. And even the content of that answer may not be right, but it's programmed to always give a response, even though if it's not programmed with the right response. So in that use, it may offer answers that aren't correct. So with this dissemination of these systems, many times produce incorrect answers and may be used by criminals in a higher scale. So the risk of production of fake news for what we call the phenomenon of disinformation also increases. This may impact elections, behavior of citizens when they need to decide essential issues in a community. So just to end here, I will pass the floor to Tatiana. And what about the systems of general proposal? I talked about ChatGPT, but there's also the modality of system of proposal, general proposal. So why do we need to regulate that category?
Por conta da cadeia de valor.
Because of the value chain, development, production, distribution, commercialization. This is a long chain of events. And the AI of general use is mixed in everything. It's in the basic programming, in that basic architecture of programming. The first supplier may elaborate that model, and that model is distributed so that other developers or suppliers may downstream in that chain of distribution may make alterations and distribute all the way to the user, the end user.
Por que é preciso regular? Porque também
Why do we need to regulate it? Because you need to pin responsibilities for each one of those participants, of those who participate in this chain of distribution of that system. So who is the supplier, the initial supplier? He needs to have more responsibility. But those who alter that system in the chain also needs to have responsibility. At the end, when the end user handles this system, he has responsibility for the moral issues. So we need regulation every step of the way. And this is, Gabriel, I give the floor to you. These are the considerations I needed to make, and I am always available. And once again, thanking for the kindness of inviting me here, enjoying the company of all of you in this wonderful beach of Porto de Galinhas. Thank you.
Desembargador, estamos encantados aqui.
We are enchanted with your vast knowledge and your capacity to give us a clear message of what's going on. Dr. Tatiana, our Vice President, the ABPI. Dr. Alexandre couldn't be here because he was blocked in the road. There was a manifestation protest, so he couldn't make it. So we had more time to talk with Mr. Demócrito Reinaldo, and now we will go. We will have space for questions, but Dr. Tatiana, please, the floor is yours.
Agora foi. Muito obrigada pela apresentação.
Thank you
Aprendi muito
for the
sobre
presentation. I learned a lot.
faz o show ao vivo, né? Ele tinha uma apresentação pronta,
Those
ele nem
who
usou.
know
A
the
apresentação ficou ali
issue,
na primeira página.
he had a presentation that was already
página ali da apresentação preparada. Então, a gente
perfect to
agradece
present. He didn't even look at it. He presented a different presentation because of the
Bom, tentando
different
trazer alguns
program.
pontos,
But I'll just bring a few points that we can debate and talk about.
eu levantei, obviamente, os tribunais.
Obviously, in the courts, we have several uses for AI. We have a hall of initiatives. And I looked at a few, and I looked more deeply at the one in Pernambuco. Then it's one that was created for an application of solutions, using AI to develop a system to analyze processes in Recife. This tool classifies the processes as far as the difference in the filing of these documents. And Bastião, who speaks of a social network that can be used to register partners with the public ministry and can help decrease certain frauds because it'd be an in-house system. And obviously that all the creations using AI are used to accelerate the process and find quicker solutions. So I went a little deeper and researched more. And we have two decisions that are very interesting. In China, we have since 2016 what is called intelligent tribunes. And they connect AI to each judge. And these systems obligate judges to consider certain levels of information. And if you just consider the recommendations of AI, you will be you will be investigated to see if you took the right decision. So this is being a success story. We have another case from Central Europe that can only consider processes with less than 700 euros. The other cases, the program will emit a decision for less than 700 euros. We have over 100 robots working for the courts. So I'd like to ask two things. First, in your view, what is being done in the initiative of the courts to transform the courts into AI institutions? Is there an exchange between the courts to look at these initiatives? And my second question is, are we moving towards having digital judgments? Do you think this will ever happen in Brazil? Is it good? Is it bad? And how will the controls be done? In your presentation, you talked about a system of controlling verification to see if the system isn't being partial to any viewpoint. So in this use of AI, how we can control it, and if the decision in the future is done by AI, do you think it will happen in Brazil? I'd like to know your viewpoints. Your considerations and your questions, you have two parts of the question. The first, as far as the initiatives of the judicial administration and implementation of tools using AI. I cited an example, two systems that are from the same same court, and there's a software that receives the requests from the processes and compares the petitions in a model of that's in its database and proposes or sends this process to certain levels of the courts. And it's used only for monetary processes that is used simply to help process these requests. The other example that you cited was Bastion, which is a program that seeks to identify predatory laws. It looks through the processes when it receives a petition, and it compares that petition to similar actions that are in the courts here in Pernambuco, in the judicial organs of the first degree, and it tries to identify certain points by the parts involved, by the content that is in the petition, so that it can eventually identify certain actions that are being handled in a high proportion. If you have a lawyer or a group of lawyers distributing hundreds of petitions that are models, it doesn't give peculiarities of cases. In some other cases, you don't even have the authorization of the parts involved. Maybe they're very old individuals, and they don't even give permission for that lawyer to enter the courts with that petition. So this is a predatory demand. And these robots or systems, AI systems, they try to combat this type of practice. This is a tool that will help the judge that work in organs of the judicial administration to try to combat this type of practice, which is considered harmful. It's a bad policy, judicial policy. So this eliminates the risk of judges have to handle and waste their time with these predatory petitions. So you gave two examples, and I will cite an initiative of the courts here in Pernambuco, and I think it will be very positive, not only to lawyers in Pernambuco, but also from lawyers all over Brazil. The program is Laura, the name, based on AI, and it will calculate not only for the costs, the judicial costs, but also it will calculate liquidation and the calculations necessary for eliminating debt throughout the process. So if you receive a judicial suit, and if you have to pay something of a debt, it will go past the sentencing phase, and you will be able to go through this Laura program that will calculate bringing all the numbers up to date and giving you the final debt of that process. So this will help us a lot and help lawyers all over Brazil. These are
as iniciativas
the initiatives
do Poder Judiciário aqui de
of public
Agora, recentemente, eu acho que foi no fim
courts
no
here
fim
in
de
Pernambuco.
2023, saiu uma notícia
And at the end of 2023, there was a note,
todos
piece of
esses
news
programas que vêm sendo
talking about all these programs that are being developed
tribunais, não só
by
tribunais
different
estaduais, mas
courts,
também
not only
da
state
ordem
courts,
da
but
justiça militar, da justiça
the military
especializada,
courts
trabalhista,
and even
tal,
specialized
eleitoral.
courts.
E parece que já se somava cerca de
And we
94
we see a number of 94 programs all over Brazil that are using AI.
Que já estavam devidamente desenvolvidos,
94 programs that are in use or being at the end of development. We have several initiatives,
desenvolvendo cada uma delas voltada
many
o auxílio
look
na
to
realização
helping
de uma determinada tarefa
a certain
para produzir
task
certos atos
or to produce
processuais
certain
relacionados
acts,
com
processual
determinadas
acts,
fases
or
ou
in different
determinadas
phases
facetas do processo
to accelerate the
judicial,
process.
mas cada tribunal tem desenvolvido
But each
suas
court
próprias
has been developing
instrumentos de inteligência
their own
artificial.
instruments and
Cada
tools.
desenvolvendo sem
And each one
cooperar ou sem compartilhar
is developing without
esses
cooperating
produtos de
or sharing
inteligência artificial
these
com os
products
demais estados,
with
com os
others,
demais órgãos do Poder
the other
Judiciário.
courts
E foi
and
aí que eu já
organisms
mencionei
of
para você
the judicial system.
que o CNJ, o Conselho Nacional de
And
Justiça,
the National
tomou a
Justice
iniciativa
Council
de
had the
estabelecer
initiative
uma
of
plataforma
establishing a
digital,
platform,
não é?
digital platform,
E essa plataforma ela vai receber, o
and this
CNJ
platform
determinou a
will
todos os tribunais
receive.
brasileiros
There was a
todos
determination
esses
for all
sistemas
courts
de
in
inteligência
Brazil,
artificial que venham a ser
all
desenvolvidos
systems
sejam
of
enviados
AI
para o CNJ
should be
para
sent
fins
to
de avaliação,
the council
aprovação
for
e
evaluation,
certificação e
approval,
disponibilização
certification,
nessa
and
plataforma, não é,
so that they may
do
be made
CNJ, para
available
que possam ser
in this platform
compartilhados,
to be
utilizados
shared or
pelos
utilized
tribunais. E
by other
muitas
courts.
dessas ferramentas elas são
And many of these
incorporadas ao processo judicial
are
eletrônico.
incorporated in the
Por exemplo,
electronic
essa última que eu mencionei
system
aqui,
of
o
courts.
Laura, é possível
The
que
Laura.
seja incorporada ao PJE.
It may be
Então, quando você
incorporated
entrar usuário
to
no
the
PJE,
electronic or
no
digital
portal,
system of the
exatamente vai ter
courts.
lá menuzinho
You
que vai
probably
ter um
will
link,
see in a
não é, pra
menu
ele entrar
a
numa
link
areazinha que vai justamente
to go
acessar
into
a
a
carga
window
programática
that will give you
dessa ferramenta,
access
desse
to this
instrumento
program,
digital.
Laura.
Provavelmente isso em breve certamente deverá estar
So this
depois de
is
avaliado
probably
e certificado
available
pelo
very
CNJ,
shortly.
é possível
This will
que
go
seja,
through
então,
evaluation and
incorporado
certification
ao
and will
programa
probably
Plataforma
be
Nacional
incorporated
de
into the
Processo
platform of the
Eletrônico.
National
Essas
Judicial
iniciativas,
Council.
elas são variadas,
These initiatives are
têm o seu
varied,
valor, e é
they
importantíssimo
are
que
valuable,
sejam realmente todas
and
trazidas para uma plataforma
need to be brought to
para que
a
também sejam
common platform
difundidas
so
para
that they may
utilização,
be divulged
mais
and disseminated
compartilhada pelos diversos
to be
órgãos,
shared among
tribunais
all
e juízes que
organisms
compõem o Poder Judiciário
that
Nacional.
form
Por
the
isso,
judicial
em boa
branch.
hora, não é? E merece todos os encômios
So
essa iniciativa
we need
do CNJ
to
de
applaud these
centralizar
initiatives
todos esses,
and applaud the
esses
initiative of
sistemas,
centralizing
esses
all of these
instrumentos de
systems
inteligência artificial
and these
criativos
artificial
para o
intelligence
auxílio,
tools
para a realização
to help
de tarefas, de fases processuais
in
e
tasks and
eventualmente,
phases of the
e acho que aí a
process.
segunda parte aí da pergunta,
And the second part of the question,
eventualmente a questão
and
da
eventually
produção do ato
in
judicial
producing the
típico,
judicial
né?
act
Que é a
that is
decisão
typical,
judicial,
the decision
decisão, despacho, sentença, acordo
or
do tribunal.
sentence or
Essa é uma
accord,
questão.
This is a big question that we have to discuss. And it will have repercussions, philosophical, chat GPT and similar systems. Will they substitute the human figure or even the judge? Recently, this week, I think it was yesterday, there was a decision in a court, constitutional court in Colombia.
Muitos leram essa decisão da Corte Constitucional
and many
da
read this
como
decision
sendo impeditivo
as
à
being
utilização de sistemas de inteligência artificial generativa, chat
as
GPT,
being
Copilot,
a prohibition
etc.
of AI systems
Eu já
by
fiz uma leitura
judges.
diferente, porque as
I read
diretrizes
it
dessa
in a
decisão
different
são o
way.
seguinte: não pode substituir o juiz
I
na
think
produção
it
de atos
said that you
judiciais.
cannot
Então,
substitute
muita gente
the
leu,
judges,
interpretou essa decisão da Corte
and many
Colombiana
people read it
como sendo
and
uma
understood that it was a
proibição à utilização.
prohibition
Eu já
of the
fiz
use
diferente.
of AI.
O que a Corte quer dizer é o seguinte:
What
olha,
I think
isso é uma
I
mera
read
ferramenta.
was that it's
É
you can
mero
use it as a
instrumento que
tool
vai
in the
auxiliar
process
os magistrados na produção
that will
de
help
atos
judges
judiciais. Então, por
in
exemplo,
producing
você vai
judicial
utilizar o
acts.
ChatGPT para estruturar.
If you're going
Por
to use
exemplo,
the chat
sempre tive
GPT to
modelos de
structure
sentença que eu vou
something,
separando.
I always have
Isso é
models
inteligência
of
artificial. Eu tenho meu banco
sentencing.
de dados
I have my
de
database of
sentenças, hoje de
sentences
acordos,
that I use as
sobre as
models
diversas
of
matérias.
accords about
E
all
toda
kinds
vez
of
que eu pego
issues.
caso
And
que
each time that I
trata
get a
sobre aquela
case
matéria,
that
por
talks
exemplo,
about the
plano de
similar
saúde,
matter,
eu
for
recorro aos
example,
mesmos
health plan,
modelos que já
I go
estão
to my
lá
model
no meu
for
banco de dados,
sentencing
eu
and
guardo lá nos
health plan.
diretórios do meu desktop. Já estão lá. Eu tenho um modelo para quase
I have
tudo.
models for
Eu
everything.
pego aquele modelo, abro
And
o
I'll go
modelo
in that
e vou, eventualmente, burilando,
file,
acrescentando,
and
replicando,
I'll
alterando,
change
extraindo
it,
algumas partes que
adapt
não
it to the
condizem
case
com o
in
caso
question that I'm
concreto que eu
looking at
estou,
now,
no momento, analisando, e vou fazendo as devidas
and I'll
adaptações.
adapt
Isso nós já
that
fazemos,
model that is
né?
previously
Isso não
prepared.
teve qualquer tipo de
That
questionamento,
didn't involve
né,
any kind
sobre
of
se
questioning.
o juiz estava, de
Uh,
certa maneira, deixando de produzir
Nobody
cognitivamente
pointed their finger
ou
at me saying that I
novas
was
decisões
not
judiciais.
producing
Existe
cognitively the
processo
decision because
que
I
é
used the model. No,
típico,
I
uma
did use my brain
particularidade
to
que
make
é
that
típica
sentence.
do judiciário
There are certain
brasileiro. Eu acho isso
peculiarities in
até
Brazilian
mais
justice
perigoso
that I
do
think
que
are
o
even more dangerous
ChatGPT,
than an
que é o
artificial
processo
intelligence
chamado em
system,
muitos advogados
which
e
is the process
advogados
that many
que
lawyers
precede
call,
a essa realidade
and that is
dos sistemas de
way
inteligência
more
artificial
old than
generativa,
artificial
que é o alto
intelligence,
grau
that
de
is the high
terceirização das
level of
atividades das tarefas
third
judiciais,
parties that are
né, através
involved
de
in making
assessores,
a
colaboradores,
decision,
não é? E que muitas
collaborators
vezes,
and workers of
em
the
certos
court,
casos
that many
até,
times the
muitos
judge will
atos são
delegate,
produzidos por assessores e não
and
verdadeiramente
that I
pelo
think is
juiz.
much
E
more
nós já
dangerous.
convivemos há muito tempo com esse processo de terceirização
We've been
dos atos
seeing
judiciais.
this for many years.
Obviamente que isso depende
Third
do grau de
third
responsabilidade de
parties
cada
involved
magistrado.
in the
Você
work
não
that
vai
should be
deixar
done by the
que
judge.
fique. Eu
You
fui
cannot
juiz
allow,
titular de vara civil por mais de 15
if I'm the
anos.
judge,
A
I've been working
distribuição
as a
da
judge for
mérita de
over
processo
15
na vara
years,
civil era
and
enorme.
the
Eu
distribution in the
recebia
civil
200, 300
branch
processos por mês.
of law that I
Obviamente, eu
handled,
não
it was
conseguiria
huge.
sozinho
Of course, I could
produzir
not
para
do
me manter
everything by
dentro das
myself,
metas de produtividade exigidas pelo CNJ.
according to the productivity
Eu não
levels that I was
conseguiria analisar
demanded to
300
have,
processos,
300
fazer audiência em
processes,
alguns deles,
and
atos
meet with
processuais
the
mesmo
parties
coordenatórios,
and
que eu não tenho controle
procedural
disso, eu não
acts.
conseguiria.
I wouldn't do
Portanto, tem
everything
que
by
ser
myself. I
efetivamente com
wouldn't be
auxílio de
able to do it.
colaboradores,
I have to
dos
count with
servidores que
on the
fazem
help
parte do
of
aparato
my
judicial.
collaborators. But what I would do is each new case, complex case, hard case, with repercussion, with economic or political repercussions, if I hadn't exposed my opinion, it would come to me. Then I would study the case and produce the sentence. Once it was produced, it would go to the database of the court, and every time the new case similar, I would say, look at the case that I judged in such and such year or month, and it's similar to this, I will have a precedent that will give you the answer. So, as far as these systems, they help you to accelerate the process. And I'm not criticizing the realities of justice systems in other countries. I think in Brazil we have a great judicial system, but we already have the third person being involved. So with the AI system, of course, it will happen just the same. We should use, because of massification,
que são trazidas ao Poder Judiciário,
a vida hoje, and the social life, it's more complex. We see a lot more conflict, and we see demands to these courts even higher every day. And if you want to be a modern judge, you need to work with AI tools, ChatGPT and others, because these are tools. You'll use them to produce a report, a sentence, and you will train and personalize, which is the great detail here, for all professionals, legal professionals. The big issue here is maybe he's a lawyer or a judge or a district attorney or whatever he is. He will have to use certain tools of AI, but he needs to work on the personification of this system so that it's every time it's more, it has more your personality, your understanding of each matter, the decisions that you produce, and you will feed that tool with your files, with your models of sentencing, context, jurisprudence, with doctrines that you believe in, and you will personify that tool to your likeness.
O seu sistema de inteligência artificial generativa para que ele tenha
respostas that tool will have answers that are similar to your professional objectives. And I think, in fact, that if you don't use these systems, if you don't use those systems, you will be left behind in this race, this high-level competition world that we live in. If you have a lawyer that doesn't use tools of artificial intelligence, he will be left behind. His production won't keep up with the rest. A judge will use it. It's a tool. You can't stop studying. You need to have responsibility to supervise, rectification of decisions, the insertion of information. So this tool should be used as a collaborator. It's as if it's an intern or someone who helps you prepare documents, and you need to adapt that tool so that he can be to your liking.
Se você é um juiz que trabalha na área civil,
you are a
você
judge
vai
that work in the civil area, you'll say, I am specialized in banks and rights of the consumer, and you need to make him think like you. That's what I would try to do as far as these tools. It's an assistant, a personal assistant. We will all use them. That doesn't mean an extermination of the judge, the figure of the judge. It'll always be a tool that the judge will have at his disposal.
De fenômeno novo que possa aparecer e que ele
and
pode
he
estar
will always have the knowledge of a new tool.
E aí o juiz é quem talvez vai ensinar ao chat GPT.
And the judge needs to teach the artificial intelligence what's new, and not vice versa. So as far as the decision in Colombia, I understood it as not prohibiting the usage of the tool, but
é que os juízes façam a utilização dessas ferramentas de
the use
modo
of these tools
responsável, para que não tenhamos o risco
in a responsible way,
produção de decisões judiciais
the production of decisions
que não desçam aos detalhes
so that they won't go into detail of concrete decisions that are for the appreciation of the courts.
Someone's producing a certain sentence, a verdict, superficially without examining or doing the examination of the evidence and the features and peculiar traits of that concrete case. And that is a great risk. It's not the replacement of judges by the machine, but it's the easy use of the algorithmic tool by the legal officials, judges, and public officials in general. And that's why we have the principle established in the PL 2338 and the European regulation of the possibility of human supervision. You have to have that possibility always of human supervision so that judges won't produce verdicts that are totally standardized and that effectively don't judge anything, that don't have to do with the case in point. Gabriel and Tatiana, that's my biggest fear, that these tools might end up being used that's not customized, or that they don't feed their data banks adequately, because these tools are generic. ChatGPT is a conversational tool of a general nature. If it is not specialized and adapted to the production of the legal activity in that particular court room, for example, it might produce useless garbage, if you will, and that will lead to big problems. The big risk, the great danger may lead to the deepening of the outsourcing process. In outsourcing, not to human collaborators, but to machines and to algorithms and foundational models and systems. That's my biggest fear, that these machines will be used without being perfected. Rather, they're producing legal jurisdiction that's less efficient and less adequate. And the big road ahead is to keep perfecting these tools, never replacing the figure of the judge. Because if you do so effectively, people might argue the unconstitutionality or the uselessness of the legal system. Demosthenes, thank you so much. Your remarks show us a deep reflection about the subject matter at hand, and hopefully your colleagues in the legal system and the judicial power at all levels, state, municipal, and federal, will hear your advice. They'll pay heed to your ideas. All of us lawyers are very much concerned. It is a shame because we could be here forever talking to appellate Judge Demosthenes, but it's over. If I would ask a round of applause for appellate Judge Demosthenes.
Mas
the works are over, but now we're going to have a cocktail party. It's out there by the pool waiting for us, Maracatu, and our party is on. So our Congress is over officially. Thank you so much.
Recording stopped.